Good day, I am Atty. Emmanuel Guerrero of Magma Channel, and I'm here to discuss illegal dismissal. Now, what is illegal dismissal? Illegal dismissal would be the termination of an employee which is not in compliance with the substantial or procedural due process. Now, what is substantial due process? Substantial due process would be the reasons for why an employee was terminated. And under our law, there's the just and authorized causes. We'll be discussing them in a separate video, but we'll go over them briefly. For the just causes, there's the serious misconduct or willful disobedience, gross and habitual neglect of duty, fraud or willful breach of trust, commission of a crime against the employer, and other analogous cases. For authorized causes, we have the installation of labor-saving devices, retrenchment, redundancy, and closure of business. We also have the C's as a ground for termination. We'll be going over to procedural due process. What is procedural due process? That is the manner in which an employee was terminated. Because even if the employer has the right reason for the termination, as long as he didn't follow the procedure, it would still constitute as illegal dismissal. Now, what are the steps to be followed? The first would be the first written notice, the second would be the hearing, and then the third would be the second written notice. What does the first written notice contain? It contains the specific charge or ground against the employee and giving him reasonable time to answer, which is at least 5 calendar days. The first notice should also contain the specific or detailed narration of facts and circumstances serving as the basis for the charge against the employee. The general description is not sufficient. Now, for the hearing, as long as the employee was given the opportunity to be heard, whether it's face-to-face or written, that would suffice. And for the third one, the second written notice would be the justification for which the employer terminates the services of the employee. Now, the second written notice should contain that the grounds have been established, justifying the severance of their employment, and that the evidences adduced during the first written notice or the hearing has been considered. Now, what do you do if you were illegally terminated? The first step should be to talk to your human resources. If you feel that the human resources department of your person that you're working for or the corporation that you're working for is not conducive, that's when you go to labor. It does not necessarily mean that you have to hire an external lawyer, because you can go to PAO in order to get one. Now, if you have any further questions, don't hesitate to comment on us and we'll do our best to answer each and every one of them. All right? Thank you.